I recall that you said that you tell Sheriff's Department employees at some point that the complaint that they send to HR is ultimately going to go to Professional Standards Division, right?
I typically email employees and let them know if that's the case.
If that's the case, okay. But so you only tell them, when do you tell them? Before or after you send it to Professional Standards Division? Or some other time?
It would be when the determination that has been made that Professional Standards is going to review that.
So it's fair to say that's after they file the complaint, correct?
Yes, I would not be able to let them know Professional Standards is going to review it before they file a complaint.
Right, or during, for example.
It would be once the determination is made.
Great. Thank you for that clarification. So I'm going to share my screen with you now. Do you see that document there?
Yes.
Have you seen this document before?
Going to object based on foundation.
Well, let's see if she recognizes it at all.
For sure.
Don't believe so. It looks like a very old version of, just based on the name, Richard Schmidt.
Fair enough. So
I don't know for sure
whether or not county written Sheriff's Department employees have revision numbers and dates on them.
I believe so, yes.
Okay. So do you see here at the bottom of this page here, do you see these revision dates?
No, but these do not follow the current policies that I know have revision dates. I don't know for this document that I don't recognize.
Okay, so these revision dates here, this 6/2018 version 2 and original issue date 2005, that doesn't indicate anything to you necessarily?
That would indicate to me that the original issue date was 2005 and it was revised in 2018.
Okay. But through your time as a business partner, you don't recognize this document?
Objection asked and answered.
That's a slightly different question.
Okay, she can answer.
I don't recall seeing this specific document, no.
Okay. And are you able, based on the document itself, are you able to identify what this document is? Based on your experience at the Milwaukee County?
Objection, Judge. She's already said she doesn't recognize this.
Yes, I think we have to stick with that answer. So please move on, attorney.
Okay. So are you aware of the sexual harassment and discrimination policy?
Objection, vague.
Well, Ms. Paul, are you aware that there is in existence harassment and or a discrimination policy, rather?
Objection. To which department?
For the
That
sheriff's
was my
department.
clarification. For human resources, yes, I'm aware that there was one. For sheriff's office, I do not know.
Okay, thank you.
Thank you.
Okay. What is the policy for sexual harassment and discrimination? Well, let's strike that. The county's policy for sexual harassment and discrimination, that applies to Sheriff's Department employees, correct?
That would apply to all county employees.
We've already established that that means Sheriff's Department employees, right?
Yes.
Okay. So again, it's fair to say that the policy that you're familiar with also applies to Mr. Novotny, for example, right?
Yes.
And Molly Zillig too?
Yes.
As well as yourself, right?
Correct.
Okay. And Mr. Lucky?
Yes.
Okay. So based on that knowledge, what is the sexual harassment discrimination? Let's just stick with discrimination policy for the county.
Without having that pulled up in front of me, I would not feel comfortable speaking to the specifics of it.
Okay. But one of your job duties is to help receive and identify discrimination complaints, correct?
Yes.
Okay. And during the last 2 years, you haven't acquired enough familiarity with the discrimination policy to inform us of what it is. Is that right?
It seemed that your question was getting at very specific information and language that I don't feel comfortable answering without having it in front of me.
Okay. Does that mean you're refusing to answer it or something else?
Objection.
Okay,
Argumentative.
I would sustain that. I think she's trying to answer the questions as best she can. She's indicated that she doesn't want to talk to it about with any specificity. So perhaps a more general.
What she needs to then do is to say that in her answer.
Okay,
And answer the question as opposed to not answer the question and have to make me guess as to why she's not doing it. That's what the problem is, and that's why we're spending so much time here.
all right. So
Got it.
ask your next question, please.
Okay. So are you familiar with any light duty restrictions or policies?
Yes.
Okay, and that's because you help administer those light duty restriction policies?
Yes.
Okay. Have you had any interaction with Mr. Lucky regarding light duty policies?
I do not recall.
Okay. What is your duties regarding light duty restrictions?
So for the sheriff's office, I assist with essentially tracking who is on light duty at any point in time, which includes a variety of employees at any time. So it's not a list of a small amount of employees by any means. So I essentially track that information, ensure that employees provide updates. I will reach out to supervisors as appropriate to place individuals in light duty assignments, as they are the ones that make that determination where restrictions can be accommodated. I will communicate that information to the employee, and essentially just track where they are in that process.
Do you record what their light duty restrictions are?
Yes.
Okay. So if Mr. Lucky was on light duty restrictions, you would have recorded it, correct?
During my time as HR business partner, yes.
Okay. So based on that knowledge and the maintenance of that list, what happens if a county employee is asked to do something outside of their light duty restrictions?
If I had awareness of that, I would review the restrictions and ask the supervisor why they were working in an assignment that was perhaps not appropriate, but I would have to be made aware of that.
Okay. And then what ability, if any, do you have to remedy that situation for the employee?
If I had a situation where it was brought to my attention and I was, upon review, it was determined it was not an appropriate assignment, I would work with the supervisor and sheriff's office management to appropriately assign them somewhere that could accommodate their restrictions,
Okay.
if able.
And you don't recall doing that for Mr. Lucky at any time?
I do not.
Okay.
However, as I stated, there are multiple employees on light duty at any given time, so
Yeah, of course.
I have to check my records.
Right. So hopefully this document can refresh your recollection. Let me know if it does, please.
Which document is this, counsel?
80.
This appears to be an email the month that I was promoted to Human Resources Business Partner.
Okay. Great. And what does this email say here? Can you read it, please? Out loud for the benefit of the recording.
Hello, Chief Deputy Ball and Inspector Hughes. Deputy Lucky has restrictions due to a right ankle injury that requires sit-down work only through December 2nd. Please advise if you approve a light duty post for him at patrol. Thank you.
Okay, and that's you who wrote that?
Yes.
Okay. Does this and do you know who Mark Wittek is?
Yes.
Who is that?
That was a former captain with the sheriff's office.
Okay, why would you have been copying him on this email, if you know?
I would need more specific context, but if he were the supervisor at patrol at that time, or if he were Deputy Lucky's supervisor.
Okay, that makes sense. Thank you. And do you know who Valerie Spreewell is?
Yes.
Who is that person?
She was a former human resources business partner during the time I was promoted. She was also helping to assist with my transition to human resources business partner. So she was often involved in similar matters, as she was also maintaining some of that light duty process as well before I was promoted.
Okay. And at this time, Danita Ball would have been the chief deputy and Daniel Hughes would have been an inspector. Does that sound right to you?
Yes.
Okay. And so you would have been copying them because of their positions in the sheriff's department, right?
Yes.
Okay. And then it says down there, please advise if you approve light duty post for him at patrol. Do you see that?
Yes.
Who would have been approving that?
That would have been Chief Deputy Ball and Inspector Hughes.
Okay. And what
Along
would
with, and my understanding is they would typically consult with the captain of that specific division.
Okay. So part of my confusions is I see at the first sentence here, it says Deputy Lucky has restrictions due to right ankle injury. Do you see that?
Yes.
And it also says that requires sit-down work only through December 2nd. You
Yes.
see that? Okay. So that, my question, you're not asking them to approve whether or not he's got light duty restrictions due to his right ankle that requires sit-down work only through December 2nd, right?
Correct. What I would be looking for when I say please advise if you approve is departments are not always able to accommodate light duty restrictions. So they're first identifying if they can accommodate, and then they are also advising where that employee will be placed depending on the needs and availability.
So in this situation here, what would have happened to Deputy Lucky if they couldn't have found a place to accommodate him?
I would need to know more specifically if it were a personal or work-related injury. Those
Okay.
sometimes get handled differently through workers' compensation.
Okay, but this is, we're talking about here is an accommodation for a disability, right?
I don't
I
know
just
if
call
it-
for a legal conclusion that this witness is not qualified to offer.
Well, why did you use the word accommodation? So I'll rephrase the question.
Thank you.
because light duty is essentially referring to accommodations, whether they are temporary, permanent, whatnot. It's more so for temporary restrictions. We are accommodating them by putting them in a light duty assignment, if able.
Okay. So it's fair to say that Deputy Lucky informed you that he had a right ankle injury, correct?
Yes, based on this document.
Okay, and then you are asking on Mr. Lucky's behalf if the sheriff's department is willing to accommodate him. Isn't that right?
If they are able to accommodate him.
Sure, able. Okay. And so if they're able to accommodate him, what do you have any knowledge of if that accommodation is at all binding on anybody?
Meaning are like permanent through
No, let's put it, I'll
December
put it another
2nd?
way. I appreciate your explaining that you're not clear on that. So what I'm trying to find out is once they put him on light duty, right, is he then, can his light duty restrictions be changed in any way?
Do you mean can his light duty assignment be changed in any way?
Thanks for that clarification. That's what I mean, yes.
Yes, it could be changed depending on the needs of the department.
Okay, so the department could say we no longer have sit-down work only through December 2nd, for example.
it would primarily be more changing their shift or what division they are placed in.
Okay,
That would be a change that may occur if business needs necessitate it.
I got it. So based on your understanding as an HR business partner, what if an employee is asked to go beyond his light duty restrictions? What happens then?
Objection calls for speculation.
I would agree with that. Sustained.
Well, you have knowledge of this, of the policy and procedure regarding light duty restriction as through your capacity as business partner, correct?
Correct.
Okay, so on that basis, can you answer that question?
My understanding is so you're stating if a supervisor were to not have them do sit-down work only.
Right. What happens then?
I would object that that's been asked and answered already, but please continue.
Thank you. I'll allow
If I
it.
were made aware of that, then I would intervene and ask appropriate questions to investigate further.
Okay. And did Mr. Lucky ever come to you with any complaints regarding light duty restrictions?
I don't recall, no.
Okay. Yeah. Okay. Um, do you recall at any time whether or not the sheriff's department contacted you regarding whether or not Mr. Lucky had made any previous HR complaints?
I believe I recall, yes.
Okay, what's your recollection?
I believe someone from, an investigator perhaps had reached out regarding that to ask if we had any record of prior complaints. But I don't think that was in my capacity as an HR business partner.
What does that mean?
I believe I was a management assistant at that time.
What would the distinction have been?
So as an HR management assistant, I would, if I were to receive a request like that, it would not have been my investigation records, as I would not have been responsible for complaints or investigations at that time.
Okay. Do you know a Mary Dutkiewicz?
Dekewitz, yes.
Appreciate that. Thank you. How do you know her?
She was the former HR business partner for the sheriff's office.
Okay. So you succeeded her in office, is that fair to say?
Yes.
Okay. She's still with the county now? How about in September of 2020?
No,
Okay. And do you recall whether or not she kept paper or electronic records?
I believe it would have been a combination of the two.
Okay. So she kept some HR records in electronic format and some HR records in paper format, is that correct?
I believe so, yes.
Okay. So when you became employed as the business manager, or as the business partner, was she still employed by the county?
No,
Okay. Were you able to contact her after she was no longer employed with the county?
I do not contact non-county employees unless that would be something at my manager's level if they needed something.
Good to know. Thank you. Did you prepare for your deposition here today?
No,
Okay. Did you review any documents for this deposition here today?
the only document that I would have reviewed was the summary of his complaint, my internal notes, not his actual complaint.
When did you read that?
Monday?
Okay. Have you provided those? So we're here on Thursday, right? So that's going to be something like 3 days ago.
Yes,
Okay. So it's fair to say that you have a fairly good recollection of those notes, correct?
yes.
Okay. Now, without telling me what you said, did you speak with anybody about your testimony here today?
No.
Okay. How did you know to review your notes in preparation for your testimony here today?
I was subpoenaed by your office related to a complaint from James Lucky.
Okay. Have you provided those notes anybody at any time?
I'm gonna,
I'm sorry, it broke up, so I didn't quite catch
Well,
what
because
you
we
said.
did, right. So let's get the answer to that. Have you provided your notes to any other person at any time?
I'm
We're
gonna
talking about
object that
notes
that's just
regarding to
vague.
Mr. Lucky's complaint here.
There we go. Thank you.
Said, have I provided my notes, because both of you talked at the same time, have I provided my notes regarding Deputy Lucky's complaint?
Hmm?
Yes.
Who did you provide them to?
Those likely would have been provided to counsel upon receipt of his complaint.
What do you mean likely?
Typically, if somebody's filing a complaint either with EEOC or something like that, counsel will then request appropriate documents so that they can review.
Okay. So, but you actually did provide those notes. It wasn't like you could have done it. You recall doing that, right? You said yes. Isn't that true?
I believe so, yes.
Okay. And by counsel, who do you mean?
It could, depending on the complaint, it could be a different person from our corporation counsel at any point. So I don't recall who it was provided to.
Okay. But it's fair to say that the corporation counsel's office had your notes after Mr. Lucky filed his complaint, correct?
I believe so, yes.
Okay. So can we have those notes, please?
For starters, I don't know if we have those. And also I don't think there's been an appropriate request for those. And without having any reason to have previously identified them, I don't actually even know if that's appropriate. So at this point in time, my answer would be no. This isn't Discovery Council.
Yeah.
No, we already had discovery and they weren't provided.
They
Counsel.
weren't asked for, counsel. We provided you an extensive amount of information to your very broad requests, to everything that I think is appropriate.
Yeah.
I object honestly to the continued use of these hearings as a discovery process. If counsel is not prepared to present his case, I don't know what we're doing here.
The word documents and materials are used in the broadest sense and refer to any and all written, recorded, or graphic matters, however produced or reproduced, whether or not it now exists, whether or not privileged, pertaining in any way to the subject matter of this action. This definition includes, but is not limited to, any and all original copies or notes of any and all of the following: correspondence, interoffice correspondence, emails, records, notes, summaries, schedules, contracts, agreements, drawings, sketches, orders, or acknowledgments, diaries, reports, forecast or appraisals, memorandum or telephone memorandum, pamphlets or brochures, letters, telegrams, computer printouts, telexes, tapes, transcripts or recording, photographs, pictures, films, computer programs or data, or any other graphic, symbolic, recorded, or written materials of any nature whatsoever. Any preliminary versions, drafts, or revisions of any of the foregoing, any document which has or contains any attachment, enclosure, comments, notation, insertion, or markings of any kind which is not a part of another document, or any document which does not contain a comment, notation, addition, insertion, or marking of any of the kind which is a part of another document, is considered to be a separate document. Okay, now let's look at the specific request. Produce all complainant employee records, including but not limited to his personnel file, medical records, documents considering compensation, attendance, job performance, termination, discipline, transfer performance, and all other records, including all documents created, maintained, or utilized for making decisions regarding employment, but including but not limited to all documents maintained pursuant to WISTAT 10409. Also, produced all documents and electronically stored information that relate to any and all defenses and an affirmative defenses in the above captioned manner. Produce all audio recordings, phone recordings, emails, text messages during the period November 1st, 2018 through November 1st, 2022 that involve, mention, or pertain to complainant. Produce all audio recordings, telephone recordings, fitness for duty referrals, and information tendered by Milwaukee County Sheriff's Office that involve, mention, or pertain to the complainant's suspension with pay, pending the psychic evaluation. Produce all audio recordings, telephone recordings, documents, and all efforts made to resolve any of the complainant's complaints. Why don't we have that document?
Counsel, you have everything in all of the files that you requested. And I would note you did not bring any, if you were unhappy with our discovery production, the time to bring that motion has long passed. This
Right,
is not discovery.
You filed those documents after that deadline. But nevertheless, what we have here now is an admission that you withheld documents. And that
no, counsel, I object to that mischaracterization
here
of my comments. I have not admitted to anything. I don't think you requested it, and I think we've turned over everything in your request to the extent of our ability. We turned over everything. We turned the county upside down looking for documents and gave you 25. Some of the information was late because we turned over 25 gigabytes of information based on how broad your requests were. And you know what? Now is not the time for discovery objections. That's long past. This is the hearing. If you don't have a case to present, then withdraw your complaints. Why are we here?
Well, in fact, what the law is that if we were prevented from putting on our case because there was documents that we requested, and now we find out that not only do they have them, but they were given to the Corporation Counsel months and months ago in preparation for this case, and yet we don't have them. She's not acknowledged that she doesn't show that she's given them to us. We've got clear testimony here from this witness that they gave them to that office, and we don't have them. And that's what the problem is. So the only appropriate thing to do here is an adverse instruction on this issue, and for you to assume that these facts are negative and counter to the respondent, and hold those facts in our favor. Otherwise, default is appropriate. This is a sanction here, sanctions in terms of costs and wasting all our time. What the appropriate remedy here is otherwise is to suspend this hearing, reopen discovery, and begin that again. This is outrageous. This is not the first time, just in this case or today, that we've come across documents that we should have had. and to say, produce all documents, all efforts made to resolve any of the complainant's complaints, and to say that her notes regarding his complaints that she had and that she personally got to review. So she's got the benefit of that. And we're sitting here blind today having to question her. And they're acting like we gave volume is some kind of a substitute for accuracy, because it's not. They're caught red-handed. And this is the time for some action to be taken here. Mr. Lucky is entitled to his day in court. He's entitled to his witnesses. He's entitled to his documents. And we've got clear evidence here that they withheld them. We asked for them. They didn't give it to us. We're sitting here prejudiced with our hands tied behind our back, and they've admitted it.
Your Honor, if I may respond.
Please.
Counsel is misstating things left and right. We've admitted nothing. He has everything in our file. 25 gigabytes of information. I actually don't know of any notes Ms. Paula is talking about. Be happy to research our files and see if we have anything, but we have given him all of that stuff he talked about, all of his personnel file. I mean, if they exist, I don't know about them. He has everything in this file that, other than privileged confidential conversations I've had, he's got everything, which he's got the privilege log for that too. I think, and I would like to also add for the record, once again, since it wasn't recorded this morning, that I am beyond offended and tired of having the personal attacks made against me. If counsel could please just make his case. Again, I don't think there's any proof here that we have withheld anything. We've given him everything. If your counsel, if Your Honor would like to reopen discovery and review all of the documents that we've provided and ensure it. However, I would argue and object that this is not the time for that discovery ruling, because your scheduling order had him bringing that well before the onset, the third day of hearing. I think it's wholly inappropriate that he's making this objection now. I don't think there's any evidence to back it, and I am tired of defending myself against baseless complaints by this attorney on this record.
So as they say, that dog won't hunt. And the reason for that is pretty clear. This witness testified that she gave that document to Corporation Counsel. Anybody in Corporation Counsel, she doesn't have to identify anybody. All of that knowledge is imputed to everybody at the Corporation Counsel. So for her to sit here and say that she doesn't have any personal knowledge, that dog won't hunt. If this witness has already testified that she gave this document to them, she has knowledge there, whether she can admit it or not. And the fact is, volume is no substitute for these notes. And here we are sandbagged. And I mean, let's be clear, whose time was being wasted here? Not just the county's time, not just your time, Judge, but Mr. Lucky's time here. And he's the one who's not getting paid to be here. He's the one who's paying to be here. And for all of his sacrifice in order to have his day in court, and we're not just talking about the hundreds of hours he's worked on this case, or the time that he's off, or the Christmas presents his kids aren't getting. What we're talking about here is that this whole thing is a waste of time. This hearing here today is a waste of time. Why do I not have this note that this witness is reading? And the county gets to have this document. They don't say it's not relevant. They admit that it's relevant. It's the notes to the complaint. And to sit here and say that we didn't ask, we specifically asked for it. We were very clear that all notes include documents. And let's be clear, the testimony isn't that she didn't just give it to the Corporation Counsel for fun. She gave it for Corporation Counsel in response to this case. And that's exactly when you get the argument here that the proper remedy is serious sanctions and default and an adverse action. Because what is required once you are in preparation for a case is to preserve all those documents. And when you have those documents, you are required to give them over when asked for them. And if you don't give them over when asked for them, and you sandbag us with that fact, and we find out during the hearing, there needs to be a significant consequence, including costs and fees. Because right now, this hearing is shambles. And for us to go any more questions with this witness is not only prejudicial, but outrageous. They had this information. She had this information. We don't have it. And that's what the problem is. And something needs to be done about it.
Your Honor, if I may object to the mischaracterization that counsel just made on the record. For starters, we do object to relevance. He's alleging that there exist notes that occurred after the fact. I mean, again, Ms. Paul testified that she received a complaint in August 2021. So all of this, again, would be occurring after the fact. Second of all, he's referring to a document that none of us have identified. I'm stating here on the record, I do not know of such document in possession of Corp Counsel. If there is such a document, it would have been turned over. It has been turned over. I don't know what he's talking about. I don't know if we've not actually identified a document. It may be among his stuff and he just doesn't recognize it. If he can show me a document, if Ms. Paul can show us a document, perhaps there's the basis. But again, this isn't the time for discovery objections. If he thought he was missing something then, that was the time to make it.
Yeah, this is precisely the time, because this is when it matters the most, and this is when something can be done about it.
There's no basis for this, and there's also no basis in the rules or statute for the sanctions that he's seeking.
You want to go over the default rules? Because let's go over them. You want to go over the adverse instruction rules? Because let's go over them.
I want to hear what the ALJ has to say. Thank you.
Well, I'd like to take this under advisement, so I'd like to take a break. Are we done with this witness? May she be released?
No, not by a long shot.
No? Okay. Well,
we only have more questions after this.
all right. I'm going to take 15 minutes. I'll be back at, well, I'm going to take 11:45.
Thank you, Judge.
Thank you.
All right, everyone, thank you for that time period. Well, during that break, was there any opportunity to find on behalf of the respondents if those notes are anywhere that you're aware of?
Your Honor, we maintain that we've turned over all documents that are relevant and non-privileged well, not even just relevant. We've turned over everything that's non-privileged. We searched high and low. We looked through our files. I can't identify a document that would match the description. At this point in time, I would argue that this is a theoretical document. It's an allegation, and we'd ask for proof that this document exists. Since this is a PC hearing, at most, we'd have to go to a hearing on the merits and do it all again. So I'm proposing that the appropriate remedy here is to ask Ms. Paul if she can produce the alleged documents. Then we can determine whether or not it was turned over, whether we've seen it before, what's the deal with it. And since this is a PC hearing, I mean, we propose that the proper remedy would be that if in fact this document exists, counsel be given time to review it. If necessary, it's likely to be cumulative of everything else we've seen here, particularly since the testimony we've already had is that she didn't do the investigation. It was done by DPS. She concurs that that's the usual process. So I doubt that there's any real prejudice here, but our position is that if it exists at all, which we don't believe there's proof of at this point in time, Ms. Paul should be given time to identify it and produce it.
Okay. Attorney Hitchcock-Cross, did you have something to say on that?
Yeah. So, I mean, it was kind of risible here to put us to the proof of it. She's admitted that there's this document, and she's admitted that she reviewed the document on Monday, not less than 3 days ago. She's also admitted that she gave it to Corporation Counsel. Corporation Counsel apparently doesn't know where it is. We've been on break for 20 minutes here. As you yourself indicated, I was also surprised that there had been no steps taken to either deliver. I still don't have the document here now.
Okay.
So that's, sorry, but we've got to then now get into prejudice here. So beyond that fact that we don't have it, what their solution here is that this doesn't really matter. It's just a do-over, non-merits hearing, probable cause hearing. Well, that's false. Mr. Lucky has his right to a day in court, just like anybody else does. The statutes and all the rules and regulations apply to him. So we need to go over clearly what the damages are, because if there's any halt to these proceedings here, then we need to have our costs and fees associated with these 2.5 days. And particularly, there needs to be some serious costs and fee shifting here due to this misconduct. Any delay at all in these proceedings need to result in cost and fees to Mr. Lucky. Not for me to even have to look at this for all the time that we have to deal with this, any sort of depositions of Ms. Paul here that's going to result from this, all those costs and fees need to be reimbursed by the respondent.
Yeah, and if I may just object to the misstatements of Attorney Hitchcock Cross as to the representations I made. We do not believe this document exists.
Okay.
We have not
Ms.
seen
Paul-
an actual document.
Okay, Ms. Paul, is it possible for you to obtain this document that you referenced and to provide it to both counsel and myself in the next hour?
I didn't hear an answer. I'm sorry.
I didn't either.
Ms. Paul is muted.
Sorry, I was on mute. Yes.
Okay, well, what I'm going to do then is we're going to take a lunch period, and right after we break here, Ms. Paul, if you would please find those notes, make a copy, send a copy to Attorney Lawrence and to Attorney Hitchcock Cross and myself, and then when we come back from lunch, we will deal with the matter.
For the record, Judge, send a copy to Ms. Lawrence, the Corporation Counsel, a second time.
Your Honor, objection.
Okay.
Objection. I'm tired of the personal attacks. Can you please?
Attorney Hitchcock Cross, that's really not acceptable. So
Thank you.
please stop with your personal attacks.
It's not a personal
I had-
attack. This is a fact.
Well,
this witness said that she
objection.
had given it to the
Misstates the
Corporation
record.
Counsel. That's just a fact.
Okay.
Objection. It misstates the
Attorney
record.
Hitchcock Cross, I think you know where I'm going with this.
I understand. Thank
I
you,
just wish you would refrain from some of those kinds of comments, please. So it is 11:56. You also need to eat lunch. We'll come back at 1:30.
For the record, Your Honor, really
yes.
quickly, I'm not sure that Ms. Paul would have contact information for you and Attorney Hitchcock Cross. I certainly don't want to be the one communicating with her at this point in time. Would you
Okay.
like to drop it in the chat, or how would you like to get that information to her?
Well, I don't know how to drop it in the chat, to be perfectly honest with you.
There might be some reasons why you don't want to put that in this forum here, Judge, on video and so
Yeah.
forth. I can see that.
Um,
It might
okay.
be better for Ms. Paul to give us her email, and then maybe the judge can forward it to from there.
Ms. Paul, is that all right with you? Okay.
Again, I guess to protect her information, I could start one blank conversation with everybody on it. Would that be acceptable?
I think that would be acceptable to me. Attorney Hitchcock Cross, will you agree to
I have
that?
no problem with keeping her email confidential, or
Okay.
as confidential as it can be. No problem at all.
Okay. All right. Okay.
Thank you.
So we will take care of that, and then at 1:30 we will come back and we will try and pick up here where we left off. Okay.
Thank you.
All right. Thank you,
Well-
everyone. Did you have something
Well,
else?
I mean, is that to say that once we get the document that we're all back and everything's fine? I mean, is that the plan here? Is to
Well,
follow the request?
my plan would be to hopefully for you to continue asking questions of her. I don't know how long this document is going to be. If you're going to ask for additional time, I can give you additional time. It would be preferable for us to keep moving along since this is day 3 and we're going to probably need a couple more days on this case.
Right, but we don't have the document that they didn't give us, so that's what, it's not on us.
I understand that there's a problem here and that we're going to try and correct right now. Okay. And
Okay.
so you'll have a chance to review that document. If you haven't had enough time, you'll tell me that at 1:30 and we'll make proper arrangements for you.
Right, yeah, because this is, the plan for right now is for us to review this over our lunch break. That's just not acceptable.
That's not acceptable. Would you like to come
That's not
back at
acceptable.
2 or 2:30?
Well, assuming we have I don't know if we have the document, but in no way is that going to cure the prejudice here of being sandbagged with this document at the last moment.
Your
I
Honor, if I may, this
understand.
is still assuming facts and evidence. The document hasn't been produced yet. At this point, his arguments are prejudicing us that
Okay.
there's an actual violation here, which has not yet been proven.
Okay, let's take first things first and get a copy of the document to both parties and
Thank you,
myself.
Your Honor.
And then we will take up the rest of the issues in due course. So do
Thank
you want
you.
additional time, 2 o'clock? Do you want to come back
Let's
at 2
see,
o'clock?
I'll send an email at 1:30 with where we're at,
Okay,
assuming we have the document.
okay. All right, so we'll plan on coming back at 1:30 unless that is not sufficient time, at which point Attorney Hitchcock Cross will notify us, and then we'll come back when he allows us.
And I just want to
Informs
put
us
my
he has a
motion on the
time to.
record, just so that it's clear that we're
Yep.
moving for all the costs and fees for the time for the today, at least.
Okay. All right, so noted.
Thank you, Judge.
Yep.
See you at 1:30, or we'll communicate
Okay.
at 1:30. Thank you.
1:30 or communication. Thank you.
Judge, is my volume substantially lower than the witnesses when you're listening?
Is your what?
Is my volume, is it less than the witnesses, for example?
Like right now, no.
No, okay, but before with Ms. Paul, could you hear her substantially better than me?
I could hear her fine. I don't know. I think it makes a difference if you have a headset or if you're
Right.
relying on your computer
Right.
speaker.
Okay. I think this camera's better at picking up room, if I got a witness here or something like that. But if it's just me, I might switch to another microphone at some point.
Yeah. Like
You
I
have
can
no
hear you
problem.
fine. I
Okay.
can hear you fine.
Great. Do you have any possible dates?
Sure. It depends on what month we're looking into.
Second and third week of March are really the best for me right now.
All right, let me see. Yeah, that looks like that week starting March 6th. I just had a case fall off.
I'll have to check, but assuming we've got to do everybody all over again, we'll need a substantial amount of time.
You mean everybody, every witness that we've called so far?
Well, certainly Novotny, everybody that's in these documents here, yeah. Novotny, Zillig, Holton, it's pretty much everybody. Oh, there we go. So are you in a state office building?
I am.
I don't think I've even seen a hearing in Madison. I don't know why I would have reason to go out there, but I have not Seen one, yeah. I suppose you have hearing rooms with nice murals and things like that?
Oh, no, we don't have any nice rooms, period. It's pretty sterile.
Spartan? Okay.
Pretty sterile. Hmm.
Well, because right, you've got the cubicles, one desk, two tables, four chairs, hearing rooms, right?
I don't know that we still have those here. Usually we're in a room that has a bunch of desks pushed together in the
Yeah.
form of a conference table.
Okay. Did you get the video upgrades out there?
Video upgrade. We did get some.
Okay. Milwaukee's got, you go in there and everything's under camera and they've got these video conference rooms and
Oh, yeah, no, we're not that lucky.
wow, we've got nothing but a small city complex here and we're oftentimes extremely jealous of Madison if nobody has told you that. So, yeah.
Well, I don't know that there's reason to be, but that's good to know. Okay.
Right.
All right, so we are back. Now we have the documents that we were interested in before. Where are we going from here, Council?
Great. So obviously we've got several issues of fundamental fairness that we've got to get resolved here. And I do have to say that I think this being the government, I think it's quite shocking that this would happen. It's very clear from the testimony, and we'll play it here, that Ms. Paul gave the document to the Corporation Counsel's office. It took her a while, but she admitted that she gave it to the Corporation Counsel's office. So whether or not Ms. Lawrence received it or not, that knowledge is imputed to everybody at the Corporation Counsel. I think that though those facts are clear, I think that a significant portion of the law really hasn't been understood here yet. We spent a significant time in our arguments discussing Ms. Lawrence's belief on what the testimony is. So we'll play that here so we can be clear on what Ms. Paul said about what she had and we know what she had now, but who she sent it to. So we want to get that on the record again to be clear so that that's in front of everybody. But then in terms of sanctions that should apply and what are the remedies here, we certainly just have not had the time that it would take to review this document, especially with regard to all the other documents that we have. Ms. Lawrence has repeatedly explained to this tribunal that she sent us a significant amount of documents, some 12 gigabytes, I think she's said repeatedly. The problem with that is that it's not only abusive, which was I think what the point was. There are LRC decisions that are on point that you can't give somebody a haystack here and call that discovery. I also point out that these discovery that they did give us was made after the deadlines for motion, but as soon as they were aware of it, which was apparently back some months ago, as Ms. Paul testified, well, you don't have to take my word for it. We'll play the tape here. But I think that that's a significant concern. I also want to raise this issue here of Ms. Lawrence's actual testimony as to what the status of this document is or what she knew or did not know. I understand she's an attorney and all of her statements are considered under oath, but I think we need to be clear then that she's making representations on behalf of the county and which are being flatly contradicted by the documents that we now have. So, I understand whether or not she may have had personally received the document or not is of no moment here. And I think that is ultimately the critical thing. It's a corporation. It's a corporation counsel. And as an attorney, acts are imputed to the client and the client's acts are imputed to the attorney. So is the law firm receiving the document. If somebody else was there that day, that's the testimonies I'm sure you're going to hear that Ms. Paul was not sure who at this Corporation Counsel's office that she gave the document to. It could have been different people on different days, but nevertheless, it doesn't matter who it was. We don't have to play around. We don't need to play these games. So I think on that brings me to this issue here that we need to have all the recordings available for all the hearings that we've had so far before we can go forward on these issues, so we can understand again what exactly the damage that has been done here. Again, there are emails in this document that we have so far. If I can have this other page, please, I'd appreciate it. So this is, for example, to Miss Paul, to Miss Zillig here, that we just spent 2 hours deposing well over time. My son wasn't that happy when he was picked up 45 minutes late for guitar, but we did that to serve her. But it turns out, hey, there's all of these documents that, in fact, Miss Zillig has intimate knowledge of. But more importantly, there's all these conversations she has knowledge of that we weren't able to confront her with. So this is also true for Mr. Holton. It's also apparently Captain Novotny also appears on this list as well. So there's significant issues here with our ability to even review these documents and go back. Sergeant Byers is also named. There's also, in addition, we have to go over Ms. Paul's previous testimony here, review these documents to make sure that those statements are all consistent there. We're going to need time to review all that to make sure that there was nothing inaccurate that was stated there. We also, of course, need to go back and look at all the testimony. That's why we need the videos of, again, Ms. Zillig, Mr. Novotny, who's here with us today, listening here. And others, I think Mr. Hughes was on here, or Mr. Holton, et cetera, that we need to go and review their statements to make sure that they were accurate here before we can go any further, because again, we should have had this document some little time ago, and certainly as soon as they knew about it, they were required to give it to us. I don't think there's any dispute about that. Just one second. There's also reference here, I believe, to other HR functionaries that we did not have a chance to, think about whether we wanted to put them on our exhibit list. So the whole exhibit list, of course, now comes into question about who is Shartisha, who is Arvis. Discussed in greater detail in Arvis, this thing says, on September 2nd of 2021. Well, we don't know who that is. So that's a significant problem. We're going to have to go back and find that out. So at the least that can be said is that all of the time, energy, effort, cost, fees that went into preparing for this hearing on Mr. Lucky's part alone, not to mention the part in my time, effort, energy, my staff time, effort, and energy, your time, effort, and energy, meaning the tribunals. Not only, and we're going to have to go and talk to Ms. Ball again, confirm her statements in regard to all this testimony. So she's going to have to be called off of her busy schedule so that we can do everything all over again. Why should Mr. Lucky have to pay for reviewing her in the first place with one hand tied behind her back? Again, I need to make very clear that this is not some ordinary employer. This is Milwaukee County. This is not some ordinary law enforcement agency. This is this is the largest county in the state. It's the largest law enforcement office in the state that I know of. And they should have been held to a much higher standard. They have a significant amount of personnel, attorneys, and so forth available who should have and had the duty, the legal obligation to provide these documents, and they simply failed to do that. Whether or not, we don't even have to get into the point of whether anybody at the Corporation Council intentionally withheld these documents. Although the nature of these documents, from my brief cursory glance, seems to be extremely contradictory to the statements that we've heard so far. And certainly there's a good deal of information from what I can see that's been left out of the statements of other people, including, for example, Ms. Pauls, although we haven't had time to adequately review this document and all the other testimony that we're going to have to review in the past hour and a half that we've been granted to do that. In addition, now I see we have another document. This is Mr. Lucky's actual complaint to HR. I don't know that that is something that we have been given or not. I have not really had time to review that fact. As the council has stated time and time again, she's given us 12 gigabytes of data. So Mr. Lucky here went through the time and effort to go through every single one of those documents, and we're very certain that he hasn't seen this notes before, but as he wrote this document himself, that's a bit harder to identify here. Certainly, it's not possible, it's overly burdensome and prejudicial to ask us to do that in something like an hour and a half with our lunch. So that's, I think, the big issues here as we see it. We obviously need briefing. We're going to need the records. I need to review the LERC decisions and be very clear. I understand what the penalties in federal court are for withholding documents. I understand the adverse instruction rules. I understand the default judgment here, which both of those remedies I think are appropriate in addition to the cost and fees. The big problem that is that I'm just not able, I've seen the LERC decisions, but I don't have them at my fingertips and certainly weren't prepared to come to brief on this issue today. I think it's significant enough, and although Mr. Lucky does not need to bear the burden of this, I think it's clear that it needs to be addressed and it needs to be addressed thoroughly for both LERC review, but also for your ability to decide on this here. To the extent that we're happy to go I think there may be ways that we can still use our time, but frankly, I think that I'm shocked. I think Mr. Lucky here is physically sort of psychologically damaged here. We've been we spent a lot of time and energy preparing for this. We sure have. And to have this document come out at the last minute, we both have kids that we could have been doing other things with than wasting our time spinning our gears with one hand tied behind our back. And certainly he's gone through every one of these documents, and this was not in here. And that's part of the problem. So we're not adequately able to prepare for this hearing. And again, I think we need to have a new hearing, and we need to be able to redo our witness list. We may need to have further discovery based on this document and what other notes she has or what other documents that they withheld. So, I think that there's a significant amount of remedy that we need to look at and examine quite thoroughly here so we can determine what really is the proper course of action, what LERC, it's clear that this has already happened before, that there's clearly precedent for this. Withholding of documents is not something that's new, but we need to be really clear on and I think the hearing examiner, we should all be clear on what the law is, what LERC thinks is the best thing to do, and so that we can all benefit from that instruction here, because I think that's really fundamentally what I'm trying to say is if we were in federal court, I think I'd be a lot better able to argue this, but on surprise notice, being sandbagged here as we are, it's really impossible to comb through the digest and come up with an adequate legal representation. And this is what this is here, is to ask us to go forward in any capacity is ultimately a violation of Mr. Lucky's due process rights. We were asked for this document. We asked for it. We should have gotten it with all the other discovery. And now it's clear that they gave it to us. And I guess it's time to play the video. So let's do that.
The only document that I would have reviewed was the summary of his complaint by internal notes, not his actual complaint. Okay.
So that's.
Yes. Yes.
Oh.
No. I was subpoenaed by your office related to a complaint from James T.
I'm gonna.
I'm sorry, it broke up, so I didn't
Well,
quite catch what you said.
right, so let's get the answer. Any other?
That's just vague. There we go. Thank you.
Said, have I provided my notes? Because both of you talked at the same time. Have I provided my notes regarding Deputy Lucky's complaint? Yes. Those likely would have been provided to council upon receipt of his complaint. Typically, if somebody's filing a complaint either with the EEOC or something like that, council will then request appropriate documents so that they can review.
So, but you actually did provide those notes. It wasn't like you.
I believe so, yes.
By council or you?
It could, depending on the complaint, it could be a different person from our corporation counsel at any point. So I don't recall who it was provided to.
Okay. But it's fair to say that the corporation counsel office had your notes after Mr. Lucky filed his complaint, correct?
I believe so, yes.
Okay. Did everybody hear that?
As best as we could. Actually, we can't hear the questions very well. I can't hear the questions very well.
Right, I could hear the testimony of Miss Paul.
Okay. So that I submit is fairly clear that Ms. Paul had given these documents to the Corporation Counsel in advance of in anticipation or in response to this lawsuit. And that's something I hadn't heard or recalled when I just said it, but there was clear that the purpose was to request these documents for review. That was the purpose. This is very serious allegations. I get it. And, you know, I would be upset too if I was in the same position. But the problem here is that Mr. Lucky is the due process rights really need to be put paramount to somebody's personal feelings about their performance, because his ability to call witnesses here has been fundamentally damaged. The fundamental fairness and the ability of this tribunal to hear all the evidence has been fundamentally damaged. The tone and tenor of this hearing has been fundamentally damaged. And again, I could go on. The problem here is I would like to cite to Lurk. I would like to cite to the record further. So for all of those reasons, I feel that the appropriate thing to do here, I mean, we may have some more questions to Ms. Paul if that's what you want to do, but I don't think that Mr. Lucky is really in any position to start testifying now, which I think was our original plan. So, I mean, how would anybody feel? How could anybody be expected to testify after they spent some 22 hours going through all of these documents, working up an exhibit list, subpoenaing people, and going through all the time, effort, and energy to come here, going through 2.5 days of testimony, and you know, telling their kids that they can't talk to them now because they got to go look at these documents here, and it turns out that it's not playing with the full deck. The jokers are missing. And we found one of them. I suspect there are more out there. So that's, I think, also what the problem is if there's notes on this, what other notes haven't we been given? That's the big problem. There's all these doubts out there about what else has been hidden. And I do think it's fair to say, although, again, we don't need that to burden ourselves with that, but I think it's fair to say that this, according to the testimony that we just heard, that she gave these documents for the purpose of review. So if they fail to review them, I guess that's on them too. But if they did review them, it's ultimately worse. And that, again, is why we submit the only proper course here, unless we've got any more questions on evidence on this that we can get from this witness. I think that's really the course that should happen. We'd like to nail down exactly who she talked to and exactly what these notes, what the note keeping here is, and basically if she's had any other communications with these people. Because I think they have been hiding behind privilege for quite some time, and that privilege, at least in this case here, is now been destroyed because if they do have these documents and they've withheld them, it's quite serious. And we need to know who got these documents. Were they received by email? Who did she send them to before? She could tell us in a second, because I know she's got that information on the computer in front of her. She knows exactly who she sent them to. So we can find that out. And then we can ask that person then, if that's what we need to do here. If Ms. Lawrence can't say that it can't be clear on imputation. But I don't think we need to do that, really. I think we're all clear on what's happened here. If you want to, if we're not clear, then let's go do it. But otherwise, I think that Mr. Lucky's fundamental rights have been violated. And to go further today would only be a further violation of those rights. Thank you.
Attorney Lawrence.
Thank you, Your Honor. I think first I would like to object to the imputation of intent. I think there is no evidence of intent or withholding in this matter. And I, again, reiterate my objection to counsel's personal attacks. That aside, I think that what we have here is evidence that Ms. Paul had a practice of sending her notes over. She thinks she likely would have. She said she believes so. There's no actual evidence that we had them. And quite frankly, the underlying complaint, which Mr. Lucky authored, was not sent to us despite our discovery requests. We asked for all information about who he reported or made claims of discrimination to the county. He never named Ms. Paul even once. This document was not provided. We had no grounds to go looking to Ms. Paul for additional complaints that would have risen to other notes. So I would actually argue that this is outside the scope of this complaint. Not, it's certainly not prejudicial here because it's based on, all the things in there are based on facts that are already been dealt with, have already been substantially explored through this hearing. I don't think there's anything further in this document that couldn't be examined or reviewed or dealt with here today. I think if he needs to recall somebody, I suppose we can do that, but I don't know what point there would be in it because Ms. Zillig was very clear that she didn't have any distinct memories of dealing with Mr. Lucky. She's not the primary investigator. She wasn't involved other than in her administrative capacity. I think it's easily responded here. And I think since we have violations of discovery on both sides, I think the answer to this is to do our best to move forward, handling the prejudice by reviewing it and re-examining the evidence as need be. Again, yes, potential discovery violations. I guess I have reviewed Mr. Lucky's discovery in thorough and not found this document. So again, we didn't know to go looking for anything related to a separate complaint to HR. It's not in his HR file. We had no awareness of this issue or notes that would be subsequent to this issue. And honestly, since it's not attached to his complaint anywhere, I guess I would argue that it's outside of the complaint that's before you. In terms of the remedies he's asking for, there's no basis for it. There's been no basis cited for it. He claims that we're hiding behind privilege. We have not asserted a privilege in this matter at all. Again, I think that the evidence that we have it is tenuous at best. Certainly it is Ms. Paul's practice. But again, because we didn't have knowledge of this complaint, it's not, we don't know that she actually was requested or had notice of this proceeding until she was subpoenaed. Again, we searched HR files. These were not in it. We've turned over everything we had. So again, to the extent that there was a potential discovery violation, it was inadvertent, whereas Mr. Lucky was specifically asked in discovery to identify all people he spoke to in the county and to provide any and all documentation of those requests or of those discussions, which he failed to do, obviously. I don't think that there's any prejudice that can't be handled here. I think counsel has been using this hearing as just in lieu of discovery and now wants another bite at the apple now that he's got more information. I think that's prejudicial to the county, who also has due process rights here, which I think have been run roughshod through this whole hearing. I mean, we spent 7 hours yesterday discussing a separate investigatory matter on an individual who's not here on the complaint to defend himself, and ended up not being relevant to this complaint because it's union matter that was subject to a separate ERD charge, not at issue and not appealed. I think counsel's bluster over this is oversold, overblown in order to cover his lack of preparation. I don't think there's anything about this particular document that would have fundamentally altered his claim or his case. I think all of the facts and issues raised in these documents have already been either the subject of testimony, the subject of evidence, or otherwise covered. There is no prejudice here, Your Honor, and we would ask to move forward with this hearing.
So I do have some important things here. To the extent that she's testifying, and that needs to be struck here. You obviously can't consider whatever her statements are about Mr. Lucky's, what he has produced in discovery or has not produced in discovery.
I would object to that. That's very much the foundation of this whole conversation. If the county's discovery is at issue, so is Mr. Lucky's.
No, I'm sorry. So what you just responded in by interrupting me was about relevance.
It's an objection, sir.
Excuse me, ma'am, this is not a dialogue. What I'm talking about here is not about whether one thing is relevant or not. I'm talking about evidence. So what we have here, excuse me, ma'am, we've got evidence here on the record made by a witness under oath. Ms. Lawrence is making assertions about Mr. Lucky's discovery production. And both what they asked for, which we don't have in the record. Well, we read out our discovery request in the record, but they haven't read out theirs. Furthermore, we don't have any evidence on what we have or have not produced or anything along those lines. So to consider any of that statements by Ms. Lawrence would be prejudicial and not hearing the actual evidence because it isn't evidence. That, I think, is the clear distinction between what we have here, a statement under oath, and her bald assertions. So if there's some issue with discovery, she's made this argument herself. If there was some issue with Mr. Lucky's discovery, or even if there still is some issue with Mr. Lucky's discovery, by all means, let's have some information on it. But what we can't have is just her private statements supported by no factual no evidence and not identified, had foundation, or put anywhere on this record. And I mean, that's, I think, the clear distinction there. Now, where she's trying to say that this document, and if you'll excuse me here, sir, is minimal, let's try to get that here on the record so that we're all, I think, quite clear about, and so that Lurk will be quite clear about what exactly we're talking about. So this document is highlighted Deputy Lucky Complaint Summary. There are several notations on here, at least 3 dates on the first page. Each one of these dates contains several facts that are apparently having occurred on this date. For example, and here's a fact that has not been introduced into evidence that nobody had before. On August 16th of 2021, according to this document, Lucky and Gladney are ordered not to have contact with each other unless in passing or absolutely necessary. So, and we've had some significant discussion about Mr. Gladney and by this witness, certainly without that fact being mentioned at any time. And of course, she said she reviewed this document a mere 3 days ago. So there's some credibility issues in terms of her ability to, or failure to remember that. Here's another one. August 18th of 2021. Lucky stated he felt unsafe at work. See below email from Sergeant Baker. It looks like we have that email. Who is Sergeant Baker? I don't know. I've never seen that name before. It says Sergeant Marie Christine M. Baker, Police Services Bureau, Court Division. I've never seen that before. Okay, now here's another one. I met with Molly. I'm going to assume that's Attorney Zillick. Captain Holton, and Captain Novotny at 1:30 to discuss next steps. So that might have been an important fact when we were discussing her discussion with Mr. Lucky about whether or not he felt safe at work. Because we then see here, he says he had told his supervisor, in fact, that I don't know who this Christine Baker, he had apparently told somebody that he didn't feel safe at work. So it appears that Miss Baker did what she was required to do under the policy. Oh, here's another one. This is an email from Mary Rozak, who I believe is the witness here, to Molly Zillig, copied to Douglas Holton. In this, she says, "Hello, Molly. I just concluded my conversation with Deputy Lucky. He confirmed that he is able to perform functions of his job and to continue working." Now, when I read that in conjunction with the statement here, I met with Molly, Captain Holton, and Captain Novotny at 1:30 to discuss next steps, I wonder to myself, what was their discussion about next steps? I see here that she just concluded her conversation with Mr. Lucky, Deputy Lucky. He confirmed that he is able to perform the functions of his job and continue working. So this witness mentioned that. She didn't mention her conversation with Molly, Captain Holton, and Captain Novotny that she had read 3 days before. She didn't. So we discussed this case with Miss Zillig, as you recall. During that, Miss Zillig was really unable to remember quite really anything. There was serious and fundamental problems with her ability to recall. This document here would have sure helped us to refresh her recollection, for example. The one that we actually have here now produced in front of us, and again, "Hello, Molly. I just concluded my conversation with Deputy Lucky. He confirmed that he is able to perform the functions of his job and continue working. I clarified that if he were to be off work, he would not need a medical clearance to return unless he was taken off by a doctor. This seems to echo what you mentioned earlier about his confusion between time off and fitness for duty." So that sounds like something that they had discussed earlier. Sure would like to have talked to Molly Zillig about that. That would have been nice. Right? Who would have understood what the next steps were? We also understand about this time now that we look at it here that they're preparing his termination. So let's keep continuing. There's a comment here that says on August 30th, there's some more dates, Lucky was making his own, quote, no contact, close quote, rules over the weekend in regards to Sergeant Byers. So this witness couldn't remember much about Sergeant Byers at all. She recalled that her name was mentioned in the complaint. She recalled that there was a bullying allegation. She couldn't recall this fact that she had reviewed 3 days before. That's quite significant. Lucky is making his own no contact rules over the weekend. I don't know what that means. Is that in regard to safety or something else? There's some significant questions here. I also see this here. Union is refusing to represent Lucky due to a conflict of interest. Well, that fact undermines everything that Ms. Lawrence just testified to about those being separate issues and the county having nothing to do with it. That's significant. Why are we only finding this out here and now? Why is this only in a comment? Why hasn't this been provided to us in discovery? Because, as again, we know for a fact, because this witness testified to it, that the Corporation Counsel had this document for the purpose of review. She did equivocate for a bit, we'll be clear on that, but we heard her testimony when she said yes, she did give it to him. Yes, I did. We can play it again because we've got the recording. So, let's keep going here. August 31st, it's also pretty significant information. Called Lucky at 11 o'clock. Conversation lasted 15 minutes. Well, she didn't remember, if you recall, her conversations with Mr. Lucky. Again, this is a document that she reviewed on Monday. That's significant. It goes to her credibility. He informed me, I assume this is Mr. Lucky, that he mailed a complaint to ERD. I'm going to read that 5 more times. He informed me that he mailed a complaint to the ERD. He informed me that he mailed a complaint to the ERD.
Okay, I think we have that, Attorney Hitchcock Cross.
I only have 3 more to go, Judge.
No, I think we're good at 2. Thank you.
Nothing like a trinity. And sent the same HR complaint to Margot. Who's Margot? Sure would like to know that. Man, I wonder if my witness list might have been different had I had that information. He stated, no offense to me, but this needs to be handled at a greater level. Sure sounds like he was having frustration that his concerns weren't being addressed and that she knew it, but, you know, of course, she couldn't recall that conversation, the one that she had just reviewed the notes for 3 days before. All right. Believe that if AI case believes, this is Mr. Lucky apparently, believes that if internal affairs cases were actually investigated, he wouldn't have been suspended in the past. Oh, boy, have we heard a lot of testimony about that the last 2.5 days. No, they remember how we finally found out only after Miss Lawrence asked Ms. Dillick exactly what the disposition of his internal affairs cases were? Oh, there was no disposition. That sure would have been nice to know. Doesn't believe it is fair he is being victimized. His example was an overtime assignment over the weekend, and it was switched to due to order to not have contact with Gladney. Boy, that would have been nice to know. I don't think I got any other information before on that. Because the key fact here isn't that Mr. Lucky knows what his statements are. It's whether or not the county had received them. Right? That's the big issue here, is whether or not we know there's discrimination going on. I think we've got past that point. The big issue here is whether or not the county knows about it and what they're doing to resolve it. And it seems like, because this is part of the case here, and it goes not only to the fundamental fairness, but also the credibility of the respondent here, meaning that Milwaukee County's corporation counsel and the county itself is not credible because this information was not provided. And again, this information contradicts the county's earlier statements. So it is curious that for some reason, this document here that contradicts the earlier statement, and in fact, Ms. Lawrence's own statements here, testimony here, that document somehow was not provided. Documents that do corroborate their statements, their theory was provided. Well, that's not how American jurisprudence works. It's just not fair to have one side have all the answers. They know where the jokers are, but we don't. And that's quite clear. Oh, looky here. August 31st, 2021. Followed up with Molly on the conversation. Bet you that's Molly Zillick. Sure would like to know why they're on a first name basis. Sure would like to know. Now, he informed me that he made a complaint to the ERD. Remember, she had so many complaints, Miss Zillig, that she just couldn't remember. Gee shucks, she could not remember all of them. Do you remember that testimony? Because I sure do. But here it is. She's telling, on August 31st of 2021, she's telling him that she filed a complaint with the ERD. Uh-huh. She didn't remember that. This witness didn't remember it. And for Ms. Lawrence to sit there and say that this is de minimis, that there's no consequence and the best thing to do is to just go forward, it's beyond laughable. But we got a lot more to go. Don't worry about it. There's a lot of secrets that have been hidden here, and I'm glad they're coming out. But again, the fact is that there's a lot more to come out. So, oh, look at this one. I again emphasize whether or not he felt safe at work. See, and I bet you that comes from Miss Zillig from over before. I sure would have liked to ask Miss Zillig about that. Also, Captain Novotny there, too. Because, of course, he was in on that conversation, but didn't seem to recall it when we were asked him about that before. Okay? He stated he just wants someone to look into his Just see how we got that half answer there? Because I see it now. I'll read this out. I again emphasize whether or not he felt safe at work. He stated he just wants someone to look into his concerns, and that is all he was looking for. He expressed that he will continue to report to work. Now, I recall, but without going to the video, I'm not quite sure, but I sure recall when this witness was talking about him being safe for work, there was no mention about he just wants someone to look into his concerns. I don't recall that statement. I sure recall her saying that he expressed that he will continue to report to work. Again, this is a document she read 3 days ago. We'll keep going.
Your Honor,
Well, go ahead, Ms. Lawrence.
I was going to say, do we have to continue to listen to Attorney Hitchcock Cross testify on this matter? Or can I respond to his allegations and then we get a ruling on how you want to proceed?
Yes, I think that's the proper course.
Thank you.
We have the document in front of us.
Your Honor, I guess first and foremost, I'm going to object to the numerous misstatements made by counsel, which were too fast and furious for me to even document all of them. I guess not only do we object to that, but we disagree that this document contradicts any of the county's prior positions or any of the evidence that has been submitted in this record so far. I also object to the counsel making the conclusion that that discrimination is assumed or proven here at this point in time. I believe that is the very issue that we are here to have you determine, Your Honor, and that is for you to determine at the close of evidence. With respect to the number, all the issues he's raising in this document he wants to know about, the author of that document is sitting right here and available to him to answer all of those questions. And to the extent that he isn't satisfied by those, if we have to recall some of the other witnesses for the purpose of discussing this document, we can certainly do so. I think that's the appropriate remedy here. In terms of his response, Christine Baker, he says he doesn't know who she is. She's in plenty of other emails we did turn over. If he had a question about who she was, he should have asked that during discovery. Which brings me to, again, the issue that there is no discovery motion properly before you. Our discovery would be part of the record if we'd had any notice that this was going to be an issue. And if, for counsel's information, request number 5 to the complainant by the respondent specifically states copies of all documents supplied, submitted, or otherwise tended to the staff of Milwaukee County Sheriff's Office as evidence of the alleged discrimination, and for each document state who the document was submitted to, the location and means of submission, the date and reasonable approximation of the time, the date that it was submitted, and any response received to the submission. Answer, see attached folder 5 and see select emails at respondent's Outlook email address. A respondent's email address has over 5 gigabytes of information. That is not a reasonable response. Again, if this were a discovery motion that was brought, we could have hashed all this before, but the hearing is not the appropriate time to do all of this. Again, the proper remedy is to ask the author of this document those questions. There is no prejudice. There is no grand conspiracy. There's no evidence of intent. This is easily remedied by Mr. Hitchcock Cross being allowed to probe this document with the witness. We'd ask that you rule that council's request for sanctions be denied and we continue on with this hearing.
Well, it appears that there's some discovery issues on both sides, so that does cause me some pause. I am certainly not in a position to go ahead and rule on whether costs and fees should be awarded to either party. I would like to take advantage of the fact that we have the author of the document that Attorney Hitchcock Cross was reading from in our presence, if we could ask her questions. But I do agree that this matter will have to be held over. The parties certainly can brief the issues of sanctions on either side. And under the rules of the division, we require the parties to conduct discovery discussions between themselves before they bring it before the division. So I certainly hope that there will be some kind of discussions between the parties to that extent, so that we don't have to go through things like this again. We don't want any more surprises. I can understand that both parties are entitled to due process, and I am very cognizant of the fact that that is exactly what would be required if this would go up on appeal, that it would come back down for additional proceedings in light of some of the information that we've just obtained. So what I propose to do at this time is to go forward with the testimony of the witness in front of us, and then we will set the matter over for further hearing, and during that time period the parties can bring the issue of sanctions if they so desire.
Great, Judge. We're ready to go forward. We just want to make it clear that we're not waiving any objections by moving forward.
Okay, that's understood.
Thank you.
Your
Okay.
Honor, I don't know if you want to deal with it now or later,
Mhm.
but in the briefing, will we be allowed to introduce or attach our discovery to complainant and his responses?
Yes.
Thank you.
Yeah, that might be, if it gets to be super large again, we'll have to work with the IT department to make sure that I have all the information before me that the parties want me to have. But that's certainly something that we will accommodate. Okay, and so Ms. Paul, I just remind you that you're still under oath. So thank you.